On April 25th, 2003, the United States Center for Disease Control broke the law. They broke 35 U.S. Code Section 101 in the filing of a patent entitled Coronavirus Isolated from Humans. Under Section 101 of 35 U.S. Code, the patenting of a substance of nature is illegal. This was confirmed, by the way, in a Supreme Court case with which we were affiliated in 2013 against Myriad Genetics. And the Supreme Court ruled in their affirmation of this that it is illegal to have a patent on a human gene. The Center for Disease Control, April 25th, 2003, filed a patent for and ultimately received United States Patent 7776521. And I need to make a very specific reference to the fact that in claims 3 and 4, the method of detecting SARS virus and a kit for the detection of SARS virus was granted with no limitation, particularly Claim 4, which reads, a kit for detecting a severe acute respiratory syndrome-associated coronavirus in a sample. That's as broad as you get. They received a patent that restricted anyone anywhere in the United States from engaging in any activity using this. Now, from April 2003 and following, the CDC owned not only SARS, but they owned the kit to detect SARS. Its ability to be detected, its ability to manufacture kits, and during that 15-year period, the effect of this grant, which was ruled unconstitutional by the Supreme Court, meant that commercial exploitation or any research involving the commercial exploitation of the virus or any kit to detect the virus would have been an infringement of the CDC patent, and therefore an infringement giving rise to CDC's actions, were it not for the fact that CDC's patent and their maintenance thereof is actually illegal. CDC and the National Institute of Allergy and Infectious Disease, led by Anthony Fauci, that's right, the Dr. Fauci that you hear, entered into trade among states, including but not limited to a corporation called EcoHealth Alliance Incorporated, and with foreign governments and foreign entities in direct violation of the Sherman Act provisions, specifically the Wuhan Institute of Virology and the Chinese Academy of Sciences, through a 2004 National Institutes of Health grant, R01 AI 110964. That constitutes commercial activity involving an illegal asset entered into interstate and international commerce in violation of the Sherman Act. The CDC and NIAID also entered into a commercial engagement with the University of North Carolina at Chapel Hill, which is obviously interstate, and with foreign nations, specifically the Wuhan Institute of Virology and the Chinese Academy of Sciences, with Dr. Ralph S. Barrick of the University of North Carolina, Chapel Hill, and Dr. Zheng Li-Shi, the head of the research component of the project that included not only the Wuhan Institute of Virology, but the National Natural Science Foundation of China. CDC and the NIAID entered into trade among states, in addition, which gave rise not only to a constructive infringement, unless there was another undisclosed agreement, on the patent that was held by CDC, with the University of North Carolina, Chapel Hill, and with foreign nations to conduct chimeric construction of novel coronavirus material with specific virulence properties prior to, during, and following the determination made by the National Institute of Health on October the 17th, 2014, that this work was not sufficiently vetted for biosecurity and safety standards. Further, it is presumed, and this is a presumption, please make the clear distinction, this is a presumption, that the CDC and its associates were A, fully aware of the work being performed using their patented technology, B, entered into explicit or implicit agreements including licensing or other consideration, and we know there's other consideration because we know the amounts of the grants that were exchanged, and C, willfully engaged one or more foreign interests to carry forward the exploitation of their proprietary technology after the United States Supreme Court rendered that technology and the proprietary rights to that technology illegal under their 2013 determination. Now, it's interesting to note that in January 2018, the U.S. Embassy reportedly sent 2 individuals to the Wuhan Institute of Virology, and in their examination found that a number of individuals and parts of the laboratory procedure were not in compliance with safe operating procedures for the level of severity of the biohazards within that laboratory. The Washington Post reported that a cable dated the 19th of January 2018 confirmed that there was, and I quote, during interactions with scientists at the WIV laboratory, they noted that the new lab has serious shortage of appropriately trained technicians and investigators needed to safely operate this high containment laboratory. A year later, in June 2019, the CDC conducted an inspection of Fort Detrick's U.S. Army Medical Research Institute of Infectious Diseases, or USAMRIID, and ordered it closed after what appears to be the same violations. And this is actually quite critical because the Center for Disease Control shut down a laboratory for the very same argument that was made when the State Department and embassy staff reportedly found the same or similar violations at the Wuhan Institute of Virology. As those information with respect to the Fort Detrick investigation are not clearly available, all we can assume is that CDC selectively and capriciously closed one lab and let another with similar violations that also had a financial interest in their activities to continue. Now, here's where it gets a little messy, folks, because CDC reported the first SARS-CoV case in January 2020. And according to the CDC's own Epidemic Intelligence Service, by the end of January to the 1st or 2nd of February, there were 650 clinical cases and what they report to be 210 tests performed. Now just stop for a minute and ask yourself the question. If the test, which reportedly was not approved by the FDA for emergency use, remember, for emergency use, was not approved until the 4th of February, how is it that in late January, allegedly the CDC had already allegedly conducted 210 tests on alleged cases of coronavirus infection in the United States? Given that the suspected pathogen was first implicated in official reports on December 31st, 2019, and only isolated within that very short period of time between December 31st and the early part of January, one can only conclude that the CDC had the mechanism and the wherewithal to conduct tests to confirm the existence of a novel coronavirus, did not have the mechanism, but falsely reported the information, and it certainly tests credulity of both the World Health Organization and the CDC that they could manufacture before anyone even knew this virus existed and had not clarified it in any form of genomic testing, that they had tests for 210 tests before any emergency use authorization was granted. Did the CDC have the test? Did they not have the test? Why doesn't the world have the test? The world doesn't have the test because from 2003 until today, the CDC illegally held, maintained, and controlled an illegal patent on both the virus and on the test that would be required to detect its presence. The reason why you can be told there is a novel coronavirus and the reason why there is no way to empirically validate whether there actually is SARS-CoV-2 or not is because the CDC maintained an illegal monopoly, restrained trade, and violated both the Sherman and the Clayton Act in their business practices with both domestic and foreign operators. Around March 12th, and this date becomes exceptionally important to the last comment I'm going to make. around March 12, 2020, in an effort to enrich their own economic interests by way of securing additional funding from both federal and foundation actors, the CDC and NIAID, Dr. Fauci elected to suspend testing as a requirement to classify a patient with COVID-19. Now, March 12th is really important. Not surprisingly, as there was a drop in reported cases, the liberalization of what constituted a suspected or presumptive positive case needed to be created to incite fear and to prop up the fear of a pandemic, which was never capable of being independently verified because of an illegal action taken by the Center for Disease Control. The CDC and the WHO elected to commit to a narrative of a novel coronavirus. And remember, they had the only ability to do so. They patented the compound of nature illegally, and then they held the patent on the test for that compound. There was no way to independently verify this. Further, they participated in exhibiting properties of virulence that include the ACE2 receptor and other spike protein properties, which are the subject of U.S. Patent 7618802, issued to the University of North Carolina's own Ralph Baric. And in the absence of testing protocols, all of them elected to insist that SARS-CoV-2 was a novel pathogen responsible for conditions that, and I'm quoting, were consistent with moderate to severe acute respiratory syndrome and pneumonia. You heard me correctly. And the reason why that last statement is so important is because as of today, there are still, with all of the liberal definitions of what counts as a COVID patient, there are still more cases since March the 12th of pneumonia of an idiopathic origin, meaning a pneumonia that comes from a pathogen we don't know. There are still more cases of pneumonia with an idiopathic origin than there are COVID cases, by over 5,000. And for those of you who like to go into the CDC webpage and do the gotcha moment on, well, but there's a reporting glitch, the problem is the reporting glitch lives in both sets of data. In both sets of data. And the pneumonia numbers still outstrip the COVID numbers by over 5,000 as of today. There is no question that on February 17th, 2014, when the Center for Disease Control paid your tax dollars to renew a patent that was declared illegal by the United States Supreme Court in June 2013, almost a year apart, when they renewed their illegal patent on February 17th, 2014, the Center for Disease Control violated Article 1, Section 8, Clause 8 of the United States Constitution. By renewing their illegal patent on February 17, 2014, the CDC willfully violated the law using public funds in light of a Supreme Court ruling that actually had declared their actions illegal on June 13, 2013. With respect to Article 1, Section 9, Clause 2, the protection of habeas corpus, Governor Gavin Newsom in California, under Executive Order N3320, based the declaration of a state of emergency and the ultimate restriction of civil liberties on, and I quote, the threat of COVID-19. There is no constitutional protection. And by the way, if you go and look at the Ju Ho case in the case in San Francisco, during the previous pandemic litigation in the Supreme Court, you'll realize that there is no protection that has ever afforded a governor in any state the right to suspend civil liberties on the threat of a thing, particularly when that threat has not been given the opportunity to be examined. No background of the underlying supporting science has been verifiable, and in this particular case, could not be verified without infringing the CDC's patent or without their collusion. Fox guarding the henhouse? Absolutely. And Governor Newsom's order, by stating that it is under the threat without any confirmed serology or confirmed immunologic evidence, violated not only his rights under Government Code Sections 8567, 8627, and 8655, which, by the way, never give anybody the right to declare an emergency based on merely an unsubstantiated threat. At the time of that declaration, neither the CDC nor the WHO had sufficient testing in place to confirm or isolate the novel coronavirus. California did not have pathology data to suggest that the epidemic was even imminent, and the rest of the United States was incapable of making any such assessment because of the aforementioned actions of the conspiring parties. Let me make this point abundantly clear. To date, there is no clinical data showing that the restraint of healthy individuals, also known as social distancing, has any empirical data supporting its use. If you look at the University of Washington, Johns Hopkins, and Imperial College models, not a single one of them mandates entire lockdown of a healthy population. The most aggressive assumptions under social distancing are set forth to be a workplace reduction of about a reduction of 50%. But in no model, in no scientific document, in no place at all has there ever been validation that quarantining a healthy population has any merit in science.